The topic chosen for today's discussion is the cause of action which is coming under Civil Procedure Code and dealt in section 15 to 20. So there are totally 6 sections are involved in cause of action that we are going to see in this video. Cause of action means, so to initiate action in the court, there should be some cause in the case instituted or the suit instituted by the plaintiff. So whenever the rights of the party is infringed, then the plaintiff seeks relief from the court basing on the fact of law or bundle of facts that is called the cause of action. ஒருவர் கோர்ட்டிலே வழக்கு தொடுக்கின்றார், அவருக்கு வாதி என்று பெயர். அந்த வாதியானவர் ஒரு நிறைய உண்மைகளோடு அல்லது லா ஆஃப் ஃபேக்ட்ஸ் என்ற உண்மை சட்டத்தை வைத்து அவர் கோர்ட்டிலே வாதாட எத்தனிக்கின்றார். ஆக அந்த பிளான்டிஃப் வாதி என்பவர் தன்னுடைய எதற்காக வழக்கு தொடுக்கின்றார் என்பதை நிரூபிக்க வேண்டும். அதற்கு காஸ் ஆஃப் ஆக்ஷன் என்று பெயர். இதனை வைத்தே கோர்ட்டு அந்த வழக்கை எடுத்துக்கொள்கிறது. இதனை அனுப்பியவுடன் டிஃபெண்டன்ட் ரிட்டன் ஸ்டேட்மெண்ட் என்று தருவார். ஸோ இதை பற்றி நாம் பார்க்க இருக்கின்றோம். ஸோ ஃபஸ்ட்டு காஸ் ஆஃப் ஆக்ஷன், நேச்சர் அண்ட் ஸ்கோப்லே காஸ் ஆஃப் ஆக்ஷன். இதை சுருக்கமாக சொல்லப்போனால் ஃபேக்ட்ஸ் அல்லஜ்ட் இன் ஏ கம்ப்ளைண்ட். சுருக்கமாக சொல்லப்போனால் உண்மை ஒரு கம்ப்ளைண்ட்லே அது அல்லது பிளைண்ட் என்பார்கள். அந்த பிளைண்ட்டை ஒரு கோர்ட்டிலே இன்ஸ்டியூட் பண்ணும் பொழுது பிளான்டிஃபால் அந்த அல்லஜ்டு ஃபேக்ட்ஸுக்கு காஸ் ஆஃப் ஆக்ஷன் என்று பெயர். நேச்சர் அண்ட் ஸ்கோப். காஸ் ஆஃப் ஆக்ஷன், த லீகல் ரைட் டு sue initiated in a lawsuit. So that is claim suffered by the facts of law. So a party claims for the suffering which a party faces, that is the plaintiff. So he has to prove the facts of law and also the legal right to sue, and he has the legal right to initiate action in the court. Then categories of jurisdiction. So there is appropriate places for initiating the suit. So that is otherwise called jurisdiction of the court. In jurisdiction there are 3 types of jurisdiction are there. One is called that is territorial jurisdiction. Suppose if the party resides, he may initiate the action in the particular place where the court is situated. Sometimes when 2 parties are involved, the case may be initiated either at the defendant side or at the plaintiff side, which are agreed by both the parties. That is called territorial jurisdiction. And pecuniary jurisdiction means each and every court have the limit that which can be dealt by the that is the pecuniary limit or the finance limit, say up to 10 lakhs, 15 lakhs, 20 lakhs or 1 crore, like that. The limit of the court is there to deal the cases which is worth to that amount, and that is called pecuniary jurisdiction. And another one is called judicial to subject matter. So according to the subject matter, they can choose the court. So these are all the categories of jurisdiction. So generally the cases can be instituted of the lowest grade of the court. Initially they cannot go to the higher court, district court, or to the high court. What are the lowest court available, that there the court, the case can be initiated. if at all, if all this jurisdiction is coming, is within the purview of that case. Then joinder cause of action. So under the joinder cause of action, so there may be one plaintiff and several defendants, and there may be several plaintiffs and one defendant, one cause of action. There may be one plaintiff, one defendant, several cause of action. Like that, this is called joinder of parties, joinder of cause of action. So several cause of action in a suit. This is to avoid the multiplicity of cases. So for each and every cause of action, they need not initiate a suit. The plaintiff need not initiate suit for each and every cause of action. So there may be several cause of action, and there may be one plaintiff. There may be several plaintiff and several cause of action and several plaintiff, and one plaintiff, several one defendant, several plaintiff. Like that, there may be this is dealt under order rule 3, order 6. This is coming under order 6 and rule 3. Yeah, plaintiff, several cause of action, several plaintiff, same defendant. Like that, this is called joinder cause of action. And I will explain the section. What the section 15 says: every suit can be initiated in the lowest grade. And section 16, relief sought in the court within local limits. So within local limits, the relief can be sought. And then section 17 says suppose a property may be situated in various jurisdiction limits. So if at all they cannot seek the relief in various courts, and a portion of the property is situated in one court or in one jurisdiction, there the case can be initiated. They need not initiate the suit in all courts. So the property may be situated in the limits of various courts, but the case can be initiated in any portion which is coming under the purview of the jurisdiction. Then section 18, local limits uncertain. Suppose if the local limits are uncertain, they could not find out the jurisdiction, then the reason can be recorded in a statement to that effect, and then the case may be initiated. Then section 19, the person may be reside in one place, and in another place there may be he may be taking some personal gain. He may be doing something in another place. So for this, this is with regard to the movable property. The suit opted by the plaintiff, that place can be taken up for initiating suit. So according to the initiation of the plaintiff, the place of court can be selected. And then section 20, it is the court of justice. It tells about the court of justice. So these are all with reference to the cause of action. Cause of action le ஒரு 6 செக்ஷன் இருக்கின்றது. இந்த 6 செக்ஷனுடைய இது காஸ் ஆஃப் ஆக்ஷன் எதை பற்றி சொல்கின்றார்? ஒரு கோர்ட்டிலே ஒரு வழக்கை எடுத்துக்கொள்ள வேண்டும் என்றால் அதற்கான முகாந்திரங்களை, அதற்கான ஃபேக்ட்ஸ் ஆஃப் தி லா, அவற்றையெல்லாம் பிளான்டிஃப் கோர்ட்டுக்கு தாக்கல் செய்ய வேண்டும். அவ்வாறு தாக்கல் செய்யும்பொழுது தான் அந்த வழக்கு கோர்ட்டிலே எடுத்துக்கொள்ளப்படும். இதற்கு காஸ் ஆஃப் ஆக்ஷன் என்று பெயர். With this we conclude this video.